I'm Kayla Kristensen and I'm a lawyer with Robertson Hyetts working in the employment law team. Over a three-part series, I'm going to discuss unfair dismissal claims for employees, specifically what makes a dismissal unfair, who is eligible to make a claim, and the process once a claim has been made. Today, we're going to look at what makes a dismissal unfair according to the Fair Work Act. The Fair Work Commission may find that you, as an employee, have been unfairly dismissed if you have been dismissed from your employment and there was no valid reason for your dismissal in relation to your capacity or conduct, and the dismissal was harsh, unjust, or unreasonable in all the circumstances. You can also be unfairly dismissed if you work for a small business, being a business with fewer than 15 employees, and the dismissal was not carried out in accordance with the Small Business Fair Dismissal Code, or your dismissal was a case of genuine redundancy. In determining if your dismissal was harsh, unjust, or unreasonable, the Fair Work Commission will consider a range of matters, including whether there was a valid reason for your dismissal in relation to your capacity or conduct, whether you were notified of that reason and provided with an opportunity to respond, whether you were allowed to have a support person present at any meetings or discussions around the dismissal, whether you had previously received any warnings in relation to your capacity or conduct, and whether the dismissal was a proportionate response to the reason for the dismissal. The Fair Work Commission will also consider other relevant factors, including the size of the business or lack of any HR management resources that may have impacted on the procedures leading up to the dismissal, your past work history, for example, whether you have a good employment record and whether you have had any previous conduct or performance issues, and the impact of the dismissal on you, which may include any financial impact. If the Fair Work Commission finds that you have been unfairly dismissed, you may be awarded compensation, or if it's appropriate, you may be reinstated to your old role. I'd now like to talk briefly about redundancy. Generally, you can't claim unfair dismissal if you've been made redundant and it's deemed a genuine redundancy. So what makes a redundancy genuine? A genuine redundancy occurs when your job is no longer required to be done by anyone, usually due to changes in the operational requirements of the business, and the employer follows any consultation requirements in the relevant award, enterprise agreement, or any other registered agreement that applies to your employment. In determining if a redundancy is genuine, the Fair Work Commission will look at whether your former employer still needs the job to be done by someone, whether your former employer followed any necessary consultation requirements, which usually includes notifying affected employees of the proposed change and providing an opportunity for that employee to provide feedback, and whether you could have reasonably been redeployed to another role within your employer's business or one of their associated entities. So, if you think you may have been unfairly dismissed because there was no valid reason for your dismissal, or because you don't think you were afforded procedural fairness throughout the dismissal process, or because you don't think your dismissal was a case of genuine redundancy, you should seek legal advice as soon as possible to understand what your rights are and whether you can make an unfair dismissal claim. It's also important to keep in mind that you generally only have 21 days from the date of your dismissal to make an unfair dismissal claim to the Fair Work Commission. Please join me next time for part 2 of the series, where I will discuss who is eligible to make an unfair dismissal claim. In the meantime, if you think you have been unfairly dismissed, please feel free to give me a call so we can have a no obligation chat about your options. Thank you.